I'm with two of my Meritas colleagues this morning, Jose and Rositza, and we're going to discuss whistleblowing in light of the 2023 EU Whistleblower Directive, which comes into force at the end of this year. Since Brexit, the UK is of course not subject to this directive, but it remains relevant for companies with wider EU operations, particularly those that are seeking to establish a consistent approach to whistleblowing across jurisdictions. And I think that's where the Meritas Employment Group can really assist clients by sharing our know-how and coming up with practical solutions. Notably, the UK has had legislative protections in place for whistleblowers since 1998, and those provide remedies for any detriment suffered by a worker or employee because of the making of a protected disclosure. And the dismissal of an employee will be automatically unfair where the making of the disclosure was the reason or principal reason for the dismissal. And our case law continues to develop in this area. Now, the EU directive goes further than UK legislation in that it also applies to self-employed individuals, shareholders, board members, as well as a category of facilitators, which is defined as someone who assists the whistleblower in the reporting process in a work-related context. And interestingly, it also sets out a prescribed timetable for responding to disclosures and providing feedback, which doesn't exist in the UK. The other main difference is the test that's applied. So in the UK, there's a subjective test where the whistleblower has to have a reasonable belief that the disclosure is made in the public interest and tends to show one or more types of whistleblowing which are specified in the legislation. And the directive is tougher, meaning that the whistleblower has to have reasonable grounds to believe that the information disclosed was true at the time of reporting. Jose, how does whistleblowing work in Spain?
Thank you, Sam. Okay, in Spain, we were late with some months of delay. The last February 21st of 2023, it was published in Spain, the rule regarding whistleblowing. This law came into force last March 13, 2023, and it established the obligation of the companies operating in Spain with 50 or more employees to have an internal whistleblowing channel. The deadline for implementing this whistleblower channel is June 13, 2023 for companies with more than 249 employees, or December the 1st, 2023 for companies between 50 and 249 employees. The whistleblower channel is also open to third parties, not only employees. As Sam told us, self-employed persons, shareholders, members of the administration, staff of contractors, even subcontractors, suppliers, including volunteers, interns, trainees, whether are paid or unpaid, are able to use this channel. Complaints can be anonymous or not, but in any case, the content must remain confidential. The company's board of directors must appoint a manager responsible for the service inside the company, and whistleblowers are protected against retaliation for a period of 2 years. This means that the dismissal of a whistleblower, which is also an employee, can be considered not only unfair, but null and void, with the obligation of the company to reinstate the employee if the dismissal causes are not clearly proven different for the whistleblower action. The penalties for the companies that breach this new regulation are incredibly high. For example, the penalty stated for the companies that are not putting in service the whistleblower channel range for 600,000 euros to 1 million euro. Then is something to bear in mind. And now I'm giving the speech to my colleague Rositza from Bulgaria. Please, Rositza, go ahead.
Thank you, Jose. So in Bulgaria, the transposing of the EU Whistleblowers Directive was also delayed, and the new Whistleblowers Protection Act was published on the 2nd of February this year. It comes into effect on the 3rd of May, and employers in the private sector with between 50 and 249 employees have a term until the 17th of December to establish the internal reporting channel. Unlike in the UK, in Bulgaria, this new legislation is the first extensive regulation put in place for protection of whistleblowers. And the circle of protected people is quite broad, and it includes not only current and former employees, but also shareholders, partners, job seekers, volunteers, trainees, and others. Also, the so-called facilitators, which Sam mentioned, are also covered by the law, and also related parties to the whistleblower who may also face retaliation due to the whistleblowing. The Act also includes rules regarding the setting up of the internal and external reporting channels. The local authority which will be responsible for the external reporting channel is the Bulgarian Commission for Personal Data Protection. And when it comes to the internal whistleblowing channel, employers are required to appoint a responsible person or department in the organization, or they can opt to engage a third-party provider of services by observing, of course, the requirements of the law. Also, companies are allowed to use an internal reporting channel, which is set up by their economic group, which would be quite convenient for multinational corporations. Another interesting thing to be noted is that the local law does not protect anonymous reporting, and also a breach can be subject to the protection of the law. A report regarding a breach can be subject to the protection of the law if the breach has been committed not more than 2 years prior to the reporting. In case of retaliation, the Bulgarian authorities have adopted a different approach, and a dismissal as an act of a retaliation is not explicitly provided in the law as subject to nullification, or the employee will not be reinstated, but there is still protection provided in the form of fines, which are to be imposed on infringing parties, which can go up to approximately 4,000 euro. And also, whistleblowers are entitled to seek damages, including moral damages, against the infringing party. And another measure for protection is that in case such damages are being sought, they are considered intentionally caused until proven otherwise, which is a good protection measure. And finally, just to mention that employers who do not comply with the requirement to set up an internal reporting channel can be subject to a fine which goes up to 10,000 euro.
Thank you, Meritas. A really interesting topic, I think, particularly for those companies that are operating across different jurisdictions. So if anyone does have any comments on the issues discussed today, then please do comment on this post and we'll respond to you. Thank you very much for listening today.